Good morning, everyone. Welcome back to the Massachusetts Post Commission. This is our 7th public meeting on certification policy, the subcommittee on certification and the policy. Welcome everybody back from the Post Commission that's in attendance. We welcome everybody that's here from the public or in the stands with us as well in person. And I'd like to put a motion on to approve the minutes of the last meeting with my two counterparts. Somebody gives me a second.
Well, just only one.
Sure, yep, fire away.
It says that last time you asked for a motion to approve, but I think you moved to approve the minute. So it's a minor little detail, and then
What
I
is it?
seconded it. The only change I have on the minute.
Yep.
Says Chair Calderon asked for a motion to approve the minutes. I think what you did was similar to what you did now, which was move that the minutes be approved, and then I seconded your motion. So that's the only change I have.
Okay.
Otherwise, I'd move that they be approved with that change.
Excellent. You okay with that, Hanya?
Yes.
Perfect. Somebody makes that change
Yep.
as we go?
So
Okay.
recorded.
All right, so moved. Thank you. At this time, I'll turn it over to the executive director for a presentation and we'll start off.
Thank you. Good morning, commissioners. I will be very brief, just to say, to turn it over to Randy Ravitz and Pauline Nguyen in a few minutes. The packet before you includes substantially a lot of information that has been presented to you before. But my colleagues are going to go through minor changes that incorporate comments received today and discussions that we have that you have agreed to today, prior to today. We'll continue with the character and fitness discussion that we have discussed in the last few meetings, and hopefully we'll get into the draft regulations that have been included in the packet for some discussion. Just by way of additional background, the packet does contain 2 versions of the same document that has notes in green and red lines in that green. That's the first document. The second document includes different versions, different colors to reflect the progression or the evolution of that document. I hope that was not confusing to anybody. Either or, we can go with the document if we get around to it. With that, I'll turn it over to Randy Ravitz to walk you through what he has this morning.
Thank you very much. I will share my screen. If anybody would find it helpful for there to be further explanation of the redlining and so forth, I can do that. If not, I will just talk about the changes that have been made since the last version that was circulated.
Masha, Hanya, you good with that? Hanya?
Yes, I'm good.
Okay, thank you.
Okay. So again, this presentation focuses on the changes that have been made to the draft set of regulations since the subcommittee last saw them, and they're based in part on comments that we received from members of the public. Now, a lot of the revisions that have been made, proposed revisions, mirror changes that were made to another set of regulations that concern the maintenance, reporting, and auditing of law enforcement records and information. That set of regulations is in the process of being promulgated. The proposed revisions to those regulations based on public comments were presented to the full commission at its meeting on September 19th. And certain of those revisions were essentially incorporated into this draft set of recertification regulations. So I'll go over what those revisions were. First, there's clarification that the regulations do not require compliance if that would violate a privilege or a law, and the commission is so informed. Second, the new set of regulations would strike the provisions that were in there previously regarding record keeping and reporting by officers, leaving those matters to be addressed in the other set of regulations that focuses largely, almost entirely on those matters. Next, instead of referring to disciplinary action for a failure to be accurate in any record keeping or any representations to the commission, the new draft refers to action being taken for untruthfulness as defined in section 1 of the statute. And as we discussed before, that's to take into account concerns about innocent mistakes, about mere imprecision, or about immaterial errors. Next, it would, like that other set of regulations, it would replace the provisions on enforcement and disciplinary action entirely, striking the provisions that would allow disciplinary action for certain acts or failures to act that were specified in the earlier draft, striking provisions that would allow for assessments, fees, fines, penalties, and sanctions on a vote of the commission, which is based on the statute, but there were some concerns raised about that, so it strikes those. And it would instead, like the other set of regulations, expressly prohibit non-compliance with the regulations on truthfulness, as noted a moment ago, and harassment, intimidation, and coercion related to the regulations. And it would allow for violations, so in other words, violations of those prohibitions to be addressed through the administrative suspension procedure with the same opportunity for review that is afforded with other administrative suspensions. And then it would allow for a violation of one of those prohibitions to be treated as prohibited conduct under the statute and regulations. And it would continue to allow information to be referred for criminal or civil enforcement, which essentially the commission could do anyway. Now, those were changes, again, that mirrored changes made to the other set of regulations, but there are a few additional changes that were made to this set of regulations based on comments that were received. First, there were concerns raised about the original definition of appointing authority, which said the law enforcement agency that employs or seeks to employ an individual as an officer, or the person or entity with the authority to appoint an individual as the head of the law enforcement agency. And the commenter correctly perceived that the idea was to say, with the head of an agency, the appointing authority is the entity or person that would appoint that agency head, and with everyone else, it would be the law enforcement agency. But the commenter was also correct that the way that it's worded with the use of the word "or" almost makes it sound like there's a choice. So there were revisions made to that definition that were intended to achieve 3 goals: to make clear that there's only one evaluating authority for each applicant; 2, to make the choice dependent on where the officer will be serving going forward; and 3, to exclude elected law enforcement officers, so really elected sheriffs, and leaving them to follow the separate set of regulations that we already have for self-sponsored applicants. So in other words, you would not have an elected sheriff evaluated by either the department that they oversee or someone else in their municipality, or I should say their county, that didn't actually appoint them and doesn't appoint them. They would have to take steps on their own to seek certification. Then there were some changes made to the performance review section, also based on the comments that were received. And that section would now continue authorizing our agency to let law enforcement agencies satisfy the requirements of certification through performance reviews. So that's a step that could be taken, but it would no longer authorize our agency to require law enforcement agencies to conduct performance reviews according to guidelines that we set. Then, with respect to the oral interview requirement, there was a suggestion made that was not incorporated into this new set of regulations, and I'll explain why. The statute requires successful completion of an oral interview administered by the commission, and the draft set of regulations provide for that to be satisfied if the appointing authority conducts an oral interview in accordance with commission guidelines, which could require various things, and such an interview is audio recorded and preserved. And what we had talked about previously, it was keeping the regulation more general, more flexible, and developing manageable guidelines separately. Now, the suggestion that was made was to instead say that the requirement could be satisfied if the appointing authority meets with the applicant to discuss the application for recertification and provides an opportunity to discuss any concerns of the appointing authority or applicant. And the reasons why that was not incorporated are that that would not expressly allow the commission to provide guidelines about exactly what should be discussed. And it would seem to allow that requirement to be satisfied with a very simple, non-substantive exchange between the appointing authority and the officer. Now, there are other sections of the regulations that will be addressed separately: character and fitness, in-service training, physical and psychological fitness. First two, my colleague Pauline Nguyen is prepared to discuss today. But I also just wanted to highlight, in response to some comments that were received, reasons to conclude that the legislature did not intend for certain requirements to be satisfied only once at the beginning of an officer's career, but instead intended for them to be satisfied in each cycle. So what's been suggested is that the legislature really intended two requirements: the CPR and first aid certificates and character and fitness to be satisfied in every cycle, but all the other requirements to be satisfied only once. And the argument was made that the commission actually lacks statutory authority to require satisfaction of those remaining 10 requirements every cycle. In other words, looking at the two parts of section 4F of the statute, you see 9 requirements in one and 3 in the other, so a total of 12. So the argument was made, people only need to satisfy 2 of them every 3 years. The others can be satisfied only once. But the legislature provided that the commission shall not recertify any person as a law enforcement officer unless the commission certifies that the applicant for recertification continues to satisfy the requirements of subsection F, again, of which there are 12. And it's hard to accept that when the legislature said continues to satisfy the requirements of subsection F, which includes 12 requirements, what it really meant was you only need to satisfy 2 of the 12, 1/6 of them. Also, with respect to one of those requirements, the one dealing with physical and psychological fitness, there's a separate section of the statute that says the commission shall have the power to adopt regulations establishing physical and psychological fitness of evaluation pursuant to section 4 that measures said fitness to ensure officers are able to perform essential job duties. So there, the legislature was telling everyone what it cared about, why it would require this, and what it was hoping to achieve. And that was to ensure officers are able to perform essential job duties. And so it is hard to see how it would ensure that when an evaluation is performed only at the beginning of someone's career. How would it assure that they are able to perform essential job duties 10 years later, 20 years later? And in fact, one subcommittee member made that observation earlier in this process, saying it would be absurd to think that the legislature believed that the fitness of a new young officer who's just coming into the profession would predict or be the same as the fitness level and the wellness level of an officer as they move through a long career in a very stressful profession. Now, those who advocated for what we've referred to sometimes as a one and done approach, that a number of requirements, 10 of them, could be satisfied only once in a person's career, pointed out some different phrasings in the statute. And they identified 2 categories. So the first category says, attaining age 21, successful completion of various things, passage of an examination. And then category 2 says possession of current first aid and CPR certificates and being of good moral character and fit for employment. And so the argument was made that this must mean that the legislature intended the requirements in category 1 that use words like successful completion to be satisfied only once, and the requirements in category 2, like being of good moral character, to be satisfied each cycle. But there's another explanation for that difference in phrasing between the 2 categories. And that is that the category 1 events occur on only one or more particular occasions, like passing an examination. You don't pass an examination all day, every day. You pass it on one occasion or 2 occasions. While the conditions in category 2, having a certificate regarding CPR training, first aid training, being a good moral character, those things are constant. They occur, they exist 24/7, even when somebody is sleeping. So that would explain the difference in the two types of phrasing. But that still says nothing about whether those things in category 1, like successful completion of certain things, must be satisfied only once or once every cycle. And so that doesn't really resolve the issue for us. And the better approach, I would say, is to construe each provision in the context of the legislature's larger goals in the 2020 legislation. But in any event, even if one were to conclude that the legislature did not require all those things to be satisfied in each cycle, the fact is that the legislature did give the commission the ability to establish additional certification requirements. So even if it's not required, the commission can do it. And this is based on several provisions of the statute, beginning with start of chapter 6E, section 3A, that says the commission shall have all powers necessary, convenient, including but not limited to those listed. That alone would give the commission the ability to establish these any additional requirements. But then it also talks about establishing with the MPTC minimum officer standards, adopting regulations that include or not and are not limited to regulations about whether an applicant has met standards for certification. It says that the purpose of the Division of Police Certification is to establish uniform policies and standards for the certification, and that it would jointly establish minimum certification standards that include but are not limited to those listed in the statute. And then says the commission shall not issue a certificate if the applicant does not meet the minimum standards enumerated in the statute or the regulations of the commission. So expressly, it's not the case that the statute precludes the commission from adopting additional requirements, even if they're not required by the statute. And the commission has previously recognized what I just said in the requirements and plan for recertification that adopted in 2022, which was included in the packet for the February 1st meeting. And subcommittee can validly conclude, if it chooses, that the better public policy is to have those requirements evaluated in each cycle. I next just wanted to address the suggestion that's been made that the legislature intended to create a presumption that certain requirements are satisfied. And I think that the better reading of the statute is that the legislature did not intend to do so. Again, they provided the commission shall not recertify any person as a law enforcement officer unless the commission certifies that the applicant for recertification continues to satisfy the requirements of subsection F. So the better reading is that I would say that by the words shall not recertify unless the legislature intended for the commission to proceed from a clean slate and affirmatively find each requirement met before recertifying an applicant. It's harder to accept that when the legislature said shall not recertify unless, what they really meant was to create a presumption that the person does satisfy the requirements unless shown otherwise. Also, say the better reading of the words the commission certifies that the applicant continues to satisfy the requirements is that the legislature meant for the commission to gather information, to evaluate it, to determine that each requirement has been met before recertifying. It's harder to accept that they really meant to just presume that the requirements have been met unless shown otherwise, or to review things superficially. And this is consistent with how the term certifies has been construed by the SJC and is defined in dictionaries in relevant context. And if anybody wants me to elaborate on that, I can do so. But also the legislature actually in the statute declined to create any guarantee of recertification, even when all the requirements have been met. And so it's, and that too is something that the commission recognized in 2022. And so it's hard to believe that that same legislature that took that approach intended to create a presumption that an officer should be recertified unless shown otherwise. And the standards that would call for disciplinary action to be taken, which, for example, based on clear and convincing evidence, the standards in that context, I would say, do not warrant a different conclusion about the recertification process, because the legislature could easily have determined to treat disciplinary action differently than recertification. Because, for example, disciplinary action, such as revoking a certification during the 3-year certification period, it changes the expectations of an officer in the middle of the period. And it also carries a stigma because in fact, anyone looking at the statute and regulations would know that it was based on misconduct. So that shouldn't change the way that the recertification provisions are reviewed, I would say. So with that concludes the presentation that I have. If the chair would like me to, I can answer any questions or respond to any comments, and otherwise I will turn the floor over to my colleague Pauline Nguyen.
Unless one of the other commissioners have a question or a comment that the two of you want to ask, if there's anybody in the public, we'll get to that at the end and we can move on to Pauline. But Marcia, Anya?
No questions at this time.
Okay, thank you.
Thank you. I too have a PowerPoint, so I'm just gonna have that set up.
You're sharing, Jamie. Good.
Thank you. So by way of a recap, the subcommittee completed its discussion and consideration of the character and fitness definition, the standards, and the types of information that could be considered when evaluating an officer's character and fitness. One item that was left for discussion by the full commission, which has been noted by staff, is the use of the term credible allegations or substantiated allegations or some other term. So that will be reserved for a future discussion. As Executive Director Zuniga mentioned at the last meeting, we received a set of public comments the day before the last meeting, and those comments address a variety of topics, but I'm focusing only on character and fitness. Therefore, there are a few policy considerations before you today. Next slide. Just to note, the main comments and concerns involve the idea that a character and fitness evaluation should be standardized, as this is helpful to the person making the evaluations, such as the chief or the appointing authority, and to the officer, so that the officer is aware or has notice of what he or she is being measured by. Therefore, the first policy decision before you is whether to make consideration of the listed standards mandatory when an officer's character and fitness is evaluated. As the packet notes, there were at least 2 public comments about this, and the proposal is a potential amendment to address these comments. Such a proposal would require the appointing authority to rely on the standards provided by the commission and not on any other criteria not included in the regulation. This proposal would also apply to the commission when applying and enforcing these standards. And I'll leave it on this slide to see if there's discussion, agreement, approval.
I'll yield to my 2 counterparts again, Hanya or Marcia, if you have anything that we want to chime in on.
Well, I mean, I think it makes sense to me, because if people want consistency and if they want to be able to go to a guideline that gives them, that informs them as to what they need to use in assessing the character of fitness, it would make sense that it would be that they all have the same requirement, which is that they shall take into account this information that's in the proposed regulations already set up. So for me, I think it makes more sense to say, shall take into account, because I think it leaves the guessing game out of it, and I think it leaves a lot of, there's less opportunity for personal stuff to come in and interfere. You've got to use these particular guidelines that everyone, it's gonna apply to everybody when making those determinations. So I would be supportive of that change in the policy decision as recommended.
Tanya?
So when I look at this, I think of this as more of an iterative process, and the concern that I would have about a hard and fast standard at this point is my concern that we may be leaving something out or not thinking of something that could be relevant. So I would propose as another option to consider that there be some combination of the shall language with a modification that allows for the evaluator to explain why there were additional factors taken into consideration if there's an extenuating circumstance.
If I can ask, council, is there a way that we can do that? Can we modify what we have there to include, what both commissioners feel?
Yeah.
Okay, so we keep the word shall, but we leave it open so that in case we're missing something, as Commissioner Bluestone's pointed out, can we do that?
I mean, one idea would be to maybe add to the standards a sort of similar language to what Commissioner Bluestone raised, in terms of, in certain circumstances, other criteria can be considered. There needs to be an explanation provided in those instances or something like that.
Yeah, makes sense.
That sound good? So is that suffice, Tanya?
Yes, for me, I think that sort of covers for the possibility of some oversight. Yes.
Okay. All right, moving on. Thank you.
Thank you. Next slide. So the second policy before you is to consider whether to remove from the character and fitness standards a consideration of the law enforcement agency's mission and value statement. Again, this is meant to address the concern that different agencies may have and apply different standards, which was raised in the public comment. The subcommittee previously proposed the addition of this language in red. One potential modification to the draft regulations to remove this language to further standardize the criteria used to evaluate an officer's character. It avoids the issue of relying on differing values in each agency. It also does not preclude a law enforcement agency from developing its own mission and value statement or an appointing authority from making an assessment that is not solely based on this.
And if it's okay, Marsha, why don't I start with Hanya this time first?
Sure.
Hanya, do you want to go first?
Sure, I think I understand this, and if I understand that this is just designed to ensure more consistency, that sort of across the Commonwealth, we're following similar missions and values, then I'm in agreement with that.
But, yeah. Okay, and to just to make sure that I'm clear, this was one of the recommendations from one of the letters of testimony we received, correct?
This is in response in general to those.
Okay, excellent. Yeah, moving on. Thank you.
I agree.
Oh, I took you as a yes when you were, sorry about that. You were shaking your head and I thought you were a yes. Thanks, Marsha. Yeah.
Next slide. And I apologize, this is a little bit out of order from the
No worries.
decisions in the memo. So the third proposal before you is to promulgate regulations instead of issuing guidance or protocol of certain instances of misconduct that can be considered in evaluating an officer's character, even if the officer has not, quote unquote, engaged in multiple instances of similar or related misconduct. To provide some background, under the current regulations, certain types of misconduct cannot be considered when evaluating an officer's character and fitness. There are two exemptions to this. One is when an officer has engaged in multiple instances of similar or related misconduct, or two, protocols have been adopted by the commission that provide otherwise. The proposal would remove number two, the reference to a protocol, and instead insert those exceptions directly into the regulations. This also addresses the concern that the officer understands and is provided notice of what is expected of the officer and further standardizes the character and fitness evaluation process. Again, an official promulgation process involves an official public comment period during which the public can provide further feedback on these areas. The proposal before you include these 5 types of misconduct when considering an officer's character and fitness. They were derived from the types of misconduct that infringes on the rights of others, particularly those that our statute, Chapter 6E, seems to focus on, such as bias and truthfulness. There are categories of conduct that require the commission to revoke one's certification. And the list also includes a determined violation of the conflict of interest law, which calls into question an officer's character and often involves the abuse of one's position. So that is also listed here. These lists of misconduct are being proposed in order to make clear to officers and provide everyone with an understanding that certain types of misconduct, even when an officer has engaged in only a single instance, can be considered in evaluating an officer's fitness. Thank you.
Sure, I like this, I think primarily because, I mean, thinking about one instance of misconduct is pretty onerous, but I think this really carefully identifies when you can do that and when you know, what kind of misconduct you would be considering if there was only one instance of it. It's so that there's not going to be some free-for-all where somebody engages in some minor or not that egregious misconduct and somebody hangs their hat on that. This makes it more onerous. It's not just something frivolous. It's got to be within these 5 outlined areas, which are also expansive, but still pretty important and pretty egregious when you think about them as being one, if you're going to consider one instance of misconduct. So I support this.
Heiner?
Yes, I think I'm in support of this as well. I would just request that in 5A, number 1, that we add the category age as we have in other areas of our regulations.
By a, which is the,
Being biased on the basis of that we add the category of age.
oh, sorry, I was in the wrong place, yes.
I agree more.
I'm getting old, so I'm sensitive to this.
Oh, one of the bias categories, yes.
Yes. Moving on.
Moving on, thank you. So the, next slide, sorry, thank you. So the 4th and final proposal for consideration is whether to require law enforcement agencies to provide a written explanation for a positive attestation. Explaining a positive attestation was raised by the public comments. The current regulation requires that for positive attestations, the appointing authority provides supporting documentation with request. For negative attestations in the current regulation, the appointing authority must make a written report to the commission. The new proposal requires that for positive attestations, a written report be made, the items that must be addressed in a written report, and that the post-commission collect all of those written reports for positive attestations. The implementation, including administrative task of the requirement to collect all attestations, positive and negative, should be weighed with the benefit of understanding the reason for an appointing authority's determination that an officer possesses the requisite character and fitness. Other options that may be considered is to require a written report, but to collect it only on request by the commission, or maybe to require a written report for positive attestation only in certain circumstances, based on a standard that's defined by our agency. That standard has not yet been defined. That can be for discussion here, or staff can propose a standard, or there are other options as well. Next slide, Jamie. Thank you. The added language in red simply mirrors language about the written report that is already required in a negative attestation context. So the types of items that go into a report has been copied and pasted into for positive attestations of the proposal.
I think I'm going to honey for us this time. Go ahead, honey.
I am not really sure how I feel about this. I kind of like the idea that there is a presumption that our officers possess character and fitness, and that there not be a need to provide written support of the positive attestation. But I don't have a strong feeling about that, and I'll defer to my my colleagues on this one.
Masha?
Yeah, I mean, I always think more information is better. But, and I do agree, that if there has been an attestation of, good character and fitness, or positive character and fitness, it's nice to be able to assume that that attestation is well-based, but I think I would, just talking out loud here, I thought about this a lot the last couple of days. I guess I could go either way, but I am tending toward, it would make sense to have a written report to explain why the officer met the requirements, and it might be helpful in the future, who knows, I don't know. So I guess I'm a little,
So you're gonna want me to comment on that?
Yeah.
Okay.
yeah, that'd be helpful.
I tend to agree with both of you on everything you're saying. Of course, I'm a police officer, and I'd like to think that if I've already been hired and attested to and already certified, that every one of my brothers and sisters that are in the field also would have that presumption that if you've been certified and you've been a police officer and your chief of your department or the police commissioner in Boston is attesting to your good moral character and recertifying you, I would think that that should be enough. I'm actually more concerned, and I'm surprised that neither one of you brought this up yet, but I'm concerned about what the departments think about it, what the chiefs think about it, because maybe for a smaller department that has 20 or 30 police officers, this may be an attainable goal to write a page and a half of why we're attesting to an officer's good moral character that we've already done in the past. But when you take into consideration larger departments, the Mass State Police, the Boston Police, Worcester, Springfield, it becomes a very burdensome and time constraining for the departments and the chiefs and anyone underneath them that's gonna have to carry this through. So I would think that this isn't something that we would put in right now. We understand we already have for an officer that's not being recertified. Naturally, we want to know why, but for somebody that's already been certified, I think that's an incredible burden that we're putting on the departments.
Yeah, as was mentioned, perhaps it was mentioned in the previous slide that there would be, an administrative burden, not just on the commission, but on departments as well. But as Pauline mentioned, there could be also a threshold, one in which, could be said, or a standard, anybody with, I don't know, 3, 5, whatever, instances of misconduct that has previously been attested to, here's the reason why. There was some, discipline, they served the discipline, nothing has happened since that, or whatever the case may be. Thus putting us with the ability to document and substantiate the reason for the public.
Could I, go ahead. So maybe I could suggest this, carrying forward. This is the last slide, right?
Yes.
My intention, commissioners, would be to move this recertification piece forward, put a motion on, move it to the full commission so that we could stay timely and get this moving. If it's okay with my two commissioners, could we take this section up within the full commission and not make any changes at this point, but let the whole commission entertain it, and that way we give some time for department heads to weigh in. That way, anybody that's in the public, any chiefs, any commissioners, the head of the state police, everybody can kind of weigh in on, maybe explain what the burden may be for them. And maybe I'm incorrect, maybe it's not a big burden and maybe we just add it in, but, short of having another meeting for this one topic, I would be inclined to take a vote if you two agree and move this forward to the whole commission as a whole. But I err on whatever the two of you say, so.
No,
Marcia?
that sounds fine to me. I just was, when I was listening to what, Executive Director Zuniga was saying, that makes sense as well, because I understand the burden that you, and that's something that I thought about as well. And then I guess what I was thinking is, if you're going to have this kind of a burden, what kind of a reward are you coming out of this? And that makes more sense if there has been somebody who's had issues in the past, but then you're certifying, that makes sense. It's not gonna happen all the time, it's left waiting some, but yeah, and what you suggested is fine. Move it forward and unless, Anya.
I agree, with, Commissioner Kezerojian that really the question here, I think that we may want to kind of lead with in the full discussion is whether the benefit of adding this outweighs any extra burden that the departments might assume. And I think also, are there circumstances where that might be more true? For instance, if there's been a history of some sort of misconduct. So yes, I'm in favor of moving this forward to the larger discussion.
So be it then. All right. And, Pauline, I don't know if that concludes your presentation or not, but, you tell me.
That does conclude my presentation. Thank you.
Mr. Director, at this time, if it's okay, and with the fellow commissioners, then, I'll put a motion on to move the entire recertification piece forward to a full commission, if we think that this is the time to do so.
I second that.
Second,
Yeah.
Anya?
Yes.
Okay. As always, I would like to, I don't know if we have any messages. Sorry, excuse me 1 second. I'd like to answer any questions that we have from the audience, and I don't know if we're gonna have live testimony. But we do have one comment in the comment section that I'd like to read for the record. This coming from Dennis Galvin. Be wary of relying on positive attestations from agencies regarding fitness of officers. This fails to take into account the problems of factionalization within the departments and also the continued tendency of some agencies to insinuate members from oversight. Oh, excuse me, insulate members from oversight. I think this should be optional and be determined on a case-by-case basis. I know I went quickly, but I know we're recording this. Do we need me to do it again, or is that? No, that's good. Okay, and that's the only one that I see in public comment online. Is there anybody in the audience that wants to give testimony live? Nick, please.
Thank you for the opportunity to testify here. Thank you, all commissioners. As I said last week.
Excuse me, I apologize. Would you just state your name and who you represent? Thank you.
My name is Nicholas Adams. I'm here on behalf of the Massachusetts Coalition of Police. As we discussed last week, and as you guys all read in our letter, we still have some concerns. We appreciate the hard work you guys have put in to addressing many of these concerns, in particular, the thing about the appointing authority. We still obviously, as you know, have some remaining concerns, putting aside the issue of the commission's authority on certain of these matters. Just from a public policy perspective, we're concerned about the lack of an explicit burden of proof with regards to good moral character and fitness. We still feel that the clear and convincing evidence standard, as it's been applied for interim certification issues, makes sense to apply here, especially where you're kind of facing the same weight. You're still facing the threat of termination in the case that they refuse to recertify you. So we still think the clear and convincing evidence standard makes sense in this context. Furthermore, we are still concerned about allowing consideration of unsubstantiated allegations. We feel that this potentially provides a backdoor for retaliation in many circumstances, and especially if there isn't a really substantial burden of proof in place. We're worried about the allowance of other kinds of evidence that didn't have an opportunity to be put up against the wall against a burden of proof. As to requiring a written report for positive attestation, I think we echo the concerns that the commissioners have brought forward about the potential burdens. Just looking at what is required to be reported for a positive attestation, which I presume will be the very vast majority of all officers in each recertification cycle, requiring a written report for every individual officer, in particular on larger departments, but as well on really small departments that don't have a lot of administrative staff, could be a very burdensome issue indeed. And lastly, as to the physical and psychological fitness standards, again, putting aside the issue of authority, we hope that the commission will be cognizant of the diverse abilities that different officers bring to departments, and not try and implement a one-size-fits-all approach on this. Especially in the midst of a massive staffing crisis and in cognizance of the fact that different local police departments are going to require officers of various different abilities. That concludes our comments now. I'm sure we'll have more substantial comments going forward, whatever the subcommittee decides to do today. But I just wanted to bring these comments forward now. And also open to commissioner questions or staff questions or any questions any of you might have.
Why don't I go around the room and just check and see?
Sounds good.
Masha?
No, I've done. Thank
Thank
you.
you.
Anya, anything?
No, I thank you. I appreciate those comments, though.
Thank you.
Thank you, Nick. Appreciate it.
Thank you.
Thank you.
Thank you, Commissioners and staff. Patrick Bryan, attorney for Boston Police Superior Officers Federation. I want to echo the comments that my colleague just presented. I thought I would highlight a few for consideration. One of which is, I think there's been the discussion about the presumption, the way it's been phrased, and that might be language that might be hard to wrestle around, but I think it's important to understand, kind of as people have been discussing, when this underlying legislation was enacted, the legislature said everyone who's currently a police officer is certified. The legislature created basically a presumption. And I think most people would understand as you go along that if an officer without good moral character is not supposed to be employed, then an appointing authority should not be appointing them. It should not be kind of a surprise. And I think because presumption may make people recoil and think, oh, well, we actually have to do some kind of affirmative obligation. I would hope it makes intuitive sense that if someone has done nothing wrong, it is fair to assume that they have sufficient moral character to do the job, which is someone has been doing the job day in and day out. They haven't violated any rules, haven't violated any policy, and asking someone to create what is essentially kind of a book report or a study on each individual officer is really not productive. I would also note, as representing the Boston Police Superior Officers Federation, and in Boston it has about 2,000 officers, that is going to be a nearly Herculean task to expect someone to be writing very individualized assessments of people who've been doing their job day in, day out, already with a vibrant and robust internal affairs division. And I also have the concern, because I think the regulations indicate that those who do the attestation must be someone who directly reports to the chief or commissioner of the agency. And I can tell you that there are, in larger departments, not just Boston, but many other sizes, there are several layers in between the rank and file officer and the commissioner. So the person who really knows the officer and what they're doing is going to be several layers of remove. So I think, again, that would be a concern. I would also note, with regard to, respect the idea of putting down clarity in what the standards are, and it's indicated that all these factors should be reviewed. And I guess what I would consider also is for the commission to think about the practicality of this. It now is numbering about 26 items. And when an officer looks at these 26 items, do they have kind of clear guidance? Yes, I have good moral character or not. How are these 26 factors applied? More importantly, if a chief or appointing authority applies those factors and concludes, what is the standard of which the post uses to determine whether someone or not has good moral character? Did they emphasize certain factors too much or too little? And again, I think it comes back to, as a practical matter, if it's certifying that someone has not engaged in the kind of misconduct or other problematic behaviors that the commission is supposed to be kind of vigilantly going after, we should assume as a practical matter that that person still has good moral character. Finally, I would note, I hope in these regulations being considered, it hasn't been discussed as of yet, but making sure that there is a process for the chiefs and commissioners that is similar to those for officers, because the attestation process online for police officers is different than it is for the chiefs. And so I think that there just needs to be some consistency there, but thank you.
Thank you.
Can I just ask a
Oh,
question?
sorry.
I'm sorry.
Yep, sorry, I didn't go around the room. My
No,
fault.
no, it's okay. It's just a quick one, and maybe I'm just missing something. So, when you're talking about the presumption, and you mentioned that, you know, all the police officers were certified in the beginning, which obviously had to happen, otherwise, once we got into, once we were appointed, that would mean if they didn't do that, every single police officer was not certified, and no one could arrest them, no one could carry on their jobs day in and day out, but it was subject to and conditioned upon being recertified going forward, as we did with the different groups. But then you talked about, you believe that once they're certified and they have not engaged in misconduct, there should be a presumption that they're always going to be certified. I'm just not sure how those two went together when you explained it. Are you suggesting that because everybody was certified in the beginning, and if we have no information, or we have to assume that unless we hear that they've engaged in misconduct, they will just continue to be certified? So I'm not sure what you were saying with that, and I just want some clarification.
I think that's the most sensible, practical approach consistent with the legislature's intention.
What
Which
approach?
is the idea that, you know, so for instance, that if someone has not engaged in misconduct. So in other words, another way to think about it, if you don't want to use the word presumption, is good moral character means the absence of these
Oh, okay,
things.
I get it.
So unless there is proof that those things have happened, someone's satisfied that definition of good moral character. I would also note, it was not just as a practical matter that the legislature, you know, certified everyone. For the first round of recertification for everybody, it was almost entirely delegated to the police departments. Nearly 100% of those that were recommended for recertification were in fact recertified. So you have, again, this kind of ongoing, for lack of a better word, understanding a difference of people in and out, doing their jobs day in, day out, have good moral character. And the idea that suddenly that has been ineffective or problematic, and there needs to be this multi-factor totality of the circumstances approach that is produced in kind of a written report for each and every officer by someone who is continuing to employ them. If they had a problem with them, they would have moved and reported them to the commission. I think that is unnecessarily cumbersome. And I also think if a written report is done and is provided to the commission, how does the commission make those decisions? The staffing that would be required to make those decisions, I think would also be cumbersome and would take unfortunate resources away.
You want on the positive one, saying the ones that are.
Yeah,
Yeah, no, I
Yeah.
get that. That wasn't my,
I'm sorry.
I understand
Right.
that point, but I understand what you're saying.
Thank you very much.
Patrick, if I could just
Yeah.
ask Tanya too, sorry, my apologies. I went around the room.
Oh.
Tanya, did you have anything that you wanted to ask Mr. Bryan?
No, I just wanted to clarify one point, which is that I assume what you're saying is that the good moral character standard would be met, but for just that recertification cycle. Right, not as an
Correct.
ongoing matter, but that,
Correct.
right, and that there wouldn't be the need for the positive attestation or the explanation, the report.
Thank you. And if I could clarify something, maybe I missed something that I'm unaware of. Did I understand you say that online, that the attestation form or requirement is different from the rank and file from the sworn chiefs?
Yes. There's a form that just kind of indicates you just do an attestation. It doesn't require that any kind of questionnaire or something else be filled out. Not the kind of detail that's been reported. That's the way it appears to us. you know, just looking at.
I wanted to clarify that. I was unaware of that because my impression was, or I was under the understanding that the chiefs were bound by the same standard that the patrol was bound by.
I think so as well.
Okay,
Now,
well,
the appointing
definitely
authority has to-
make sure that we take a
We can
look.
compare them.
Yeah, second, fine.
Thank you.
Thank you.
Thanks. Anybody else? We're good? Okay, Mr. Director?
Well, this really is your pleasure, commissioners. If you're ready with what was presented, I mean, did you feel we needed to go through the other document in detail?
Well, we took
I
a
mean-
vote to move it forward, so I
Yeah.
think we were good.
I think we're good. Yeah, I mean, it was addressed via the presentation and the policy questions that Randy highlighted.
Is there anything that matters that I didn't become aware of that either of you want to? Oh, sorry, excuse me, 1 second. Sorry.
There is one more thing. Yeah, and Randy, thank you for reminding me. We included in the packet, something we call the sample, agency questionnaire.
The survey.
Which is a survey. I can just,
Please, yes.
introduce it and maybe, Lucy or, who might join us a little bit if they need to. Give you a minute. Just by way of background, in a prior meeting, when we were talking about this topic of, health, physical and psychological health, there was discussion, around conducting a survey. The gist of that discussion was that part of, recertifying people could serve as a survey itself of surveying all the way down to the officer level. But there was also an interpretation afterwards that we could conduct a survey currently in parallel to this process of regulations on the agencies to get smarter about what is out there that we just hear about anecdotally. And so what the team has put together here is a sample of questions meant to be 10 to 15 minutes to complete that we might deploy to agencies to get, again, our data on what resources are there out there for officers relative to health and psychological and physical health. With that, do you want to expound on that? And it is at the end of the packet for commissioners. It's a 3-page document.
Sure, so just to introduce myself, my name is Elizabeth Smith, and I'm a paralegal with the General Counsel's division. Jamie, I sent you a PowerPoint, sorry. I sent it kind of last minute, so. Yeah.
Yeah, and for reference, commissioners, it's, you know, the packet is here in there.
And while Jamie's pulling that up, I will keep this pretty brief. I've been working on this with, Deputy General Counsel Lightfoot and Counsel Annie Lee. And we really see this as just collecting information on what's out there. So we've received feedback from, other chiefs and, officers throughout the state. And, you know, there are a lot of initiatives being done already. So instead of recreating the wheel, you know, we want to see what works, what doesn't work, and recognize the work that's already being done. PowerPoint.
Is it PowerPoint?
Sorry, I don't see it.
Oh, I sent it to you on Teams. I can also email it if that's easier. Okay.
Does someone else have it or?
You want to take my hard copy? You can just get my.
No, I have.
Oh, yeah,
our
the
slides.
presentation
Yeah.
that you want to go through?
Sorry for the short notice.
No, no.
While we're waiting for that, can I make one suggestion? When I was reading it, instead of calling it a questionnaire, can we call it a survey?
Sure.
Just questionnaire brings up some kind of. Well, it just makes it separate from.
Yeah, we don't want to distinguish, we want
Yeah.
to distinguish the other.
Oh, yeah, sure. Yes.
Folks, there's two more comments in the question and answer section. If I can read them while Jamie's working on that. The first one comes from Frank Frederickson. The positive attestation does not accomplish anything useful and creates a tremendous burden on departments. Imagine over 18,000 reports, question mark. Once again, one by Dennis Galvin. It would be a ponderous task to require agencies to submit positive attestations for each officer whenever they are up for recertification. Consider the approach taken by the U.S. Office of Personnel Management, OPM, the agency that grants security clearances for the federal government. Once a clearance is issued, it can only be challenged by an allegation. The allegations are classified as 1, financial trustworthiness, 2, issues related to sexual predators, 3, issues with associations, 4, sobriety, 5, mental fitness. When these issues arise with someone, holding a clearance and investigation must be conducted and finding rendered as the issue, and then the clearance is reviewed. So that's by Dennis Galvin, and those were the two additions to the question and answer section. You ready?
Yes, I just sent it to Jamie, so she should be able to pull it up in a moment. I'm sorry about the.
If you don't have it, I can show it.
Randy can share.
Okay.
Is that all right? Oh, okay, no, go ahead.
Oh, no, if you have it, please. Feel free. I do have it now, though.
Great, thank you, Jamie.
Yep.
So if you move to the next slide, this is just a brief agenda of what I'm going to cover. Please stop me, along the way if you have any questions or if I'm going too fast. Next slide, please, Jamie. So this is just a brief, timeline of, what was discussed at previous subcommittee meetings and kind of how we ended up here. So in the February, 2024 subcommittee meeting, I presented a summary of my research on physical and psychological fitness standards from other jurisdictions. And my research revealed that, most states, don't have renewing, physical and psychological fitness standards as part of the recertification process, but it's on the forefront of a lot of, states' agendas, and, new legislation was introduced in states like New Jersey and Illinois, to have ongoing mental health screenings. And, this will likely increase as physical and psychological fitness, becomes a priority for decision makers. So then during the April 2024 subcommittee meeting, like Executive Director Zuniga said, there was a suggestion made to prepare a survey to gather information available on resources in the Commonwealth and how often they're used. So a draft survey was created for the July 2024 subcommittee meeting, but just because there was a lot on the agenda, we weren't able to address that. So since that last submission, Council Lee and I have kind of changed the questions to be more general and collect information specifically on resources in the state. And just, I wanted to say thank you to Commissioners Crispin and Baker for letting us speak with them on the previous iteration and getting their input on what chiefs would like to see and the format of the survey. So next slide, Jimmy. So this is just a brief summary of the feedback that we received at the previous subcommittee meetings. Some departments have existing physical and psychological fitness initiatives and standards. So we're not starting from scratch. There are resources out there that we can capitalize on and potentially share with other agencies. other agencies presented on some initiatives that they are sponsoring, like wellness days, having on-staff clinician and an on-site workout facility. And you know, other agencies are using peer support network or you know, working with local nonprofits and other organizations to fund these initiatives. So next slide, Jean. So this is an overview of the revisions that we made to the July submission. Like I stated earlier, the sample questionnaire was included in the July subcommittee packet, but we weren't able to address that. So this focuses on both physical and psychological fitness, whereas the prior version was focused solely on physical fitness. We decided to focus on both just for conciseness, and so agencies don't have to submit two questionnaires. We also made the questions more general in the hopes of yielding high agency participation. We know that agency heads are extremely busy, and so we want to be cognizant of their time and try and be as efficient as possible. This new iteration is limited in scope to only collect information on existing resources. It doesn't go into implementation or details of the fitness evaluation. Thank you to Chief Hicks and Jim O'Brien from the MPTC for providing us input on this. We really are open to collaboration and you know, want to make or collect good data. So on the next slide, I have a link to a mock-up of the survey. So Jamie, if you want to click on that, you can.
Is this what's in our packet?
So it's the same like information, it's just a different like format. So this is like what it could look like. If you can't pull it up, that's fine. It's the same information. But
I think Randy was sharing.
Yeah, but it's,
oh,
It's,
it's up, but on here, but not.
that's okay.
maybe you need to share a different window. It popped up in another window. You were. So stop sharing and now share that window.
But we have it already.
Yeah, if you can't open it, that's totally fine. And I'd be happy to send a link to that later if the commissioners are interested in looking at that. Oh, this is it. So the idea was to have it like available both on the computer and on the cell phone. So it can be completed, you know, at any time, and is supposed to be quick. So, you know, there are a lot of multiple choice, and there's the opportunity for chiefs to expand on, you know, whatever they submit, but it's, you know, we want to be cognizant of their time. So Jamie, or Randy, sorry, next slide.
Start now?
Yeah. Oh, wait, sorry, I meant of the PowerPoint. I was just gonna go back to that, sorry.
Start the PowerPoint.
So. This one?
No, I think you
Okay.
started the survey. You wanted the PowerPoint?
Yeah,
to
yeah, this is
continue?
it.
Yeah.
And then to the next.
Okay.
The summary of questions, yeah. Thanks, Randy. So really, there's different sections. It's broken up into physical and psychological fitness. First, we get an idea of if an agency has any testing requirements and the frequency of the tests. Then we go into any resources, programming, or opportunities offered to officers and frequency of use. Next, we ask about successful programs that agencies may have done and any like challenges that they identified for maintaining physical and psychological fitness. And then we ask about agency policies surrounding physical and psychological well-being. And we hope that we can, you know, get good data on what agencies are already doing. So last slide, maybe. Thank you. So this is like kind of the next steps, broad strokes. We would like to send the survey to agency heads. We talked about sending it through Mass Chiefs. I think that casts a wide net. I know it doesn't encompass everyone, so there are other like mailing lists for like McLeod for, campus, officers and other organizations. But our timeframe, after sending this out is giving, agencies a month to submit this. So we will have incremental reminders, at the 2-week mark and then the 1-week mark. And once we're able to, look at the data and, kind of organize it, we would present our findings to the subcommittee, at a later meeting. So thank you, and I'm happy to answer any questions.
Let me go around the room first, and I'll start with Hanya. Any questions or anything on this yet? Did we lose Hanya already?
No, I see it. I thought.
Well, I think I don't see.
Oh,
That's
maybe,
right.
Yeah, I think we lost Hanya. Hanya had something,
Oh, okay.
that she had to do too.
I don't have any questions. No, thank you for that presentation.
I have a couple of things. So
Sure.
if, and this might not be to you, Mr. Director, we put a motion on that we passed and move forward the good moral character and fitness portion. Does that include the survey? For the record?
No,
It
it
doesn't.
didn't. It didn't.
Okay, so we'll come back to the survey then at another date and time, or what was the expectation?
Well, the expectation was to get your feedback, your general sense as to whether you were on board with this based on the prior discussions. We didn't want to deploy it, let's say, to try to get data without you weighing in and saying, well, you should be asking a different question, or you should be asking additional questions. So if you're not ready to react to it today, we can
Oh, I can
postpone
if
it.
you want.
I mean, I think my only concern was that because we lost Tanya, we don't have her input. Is this something that we can include?
No, sorry to.
Yeah, yeah.
Yeah,
please.
Tanya is trying to get back on. She said.
Oh, she is. Oh, good. Okay, let's wait a couple of minutes. We can talk to Tanya, because what I was gonna suggest was to move this to the full commission as well.
Okay.
But I didn't know if we had the authority to do that without Hanya. But while we're waiting for her, I did make a couple of notes, because we're on a few different hats. So and I know that this is probably not your decision making, but I have a question to everyone as a whole. There are a lot of comments about, I got Chief Baker, Eddie Crispin, Chief Hicks, one other person that I missed in your presentation, but I didn't hear any input from rank and file officers, their organizations. And that is one thing that I want to comment on, because when we're talking about anything that has to do within the post commission itself, but especially physical fitness, mental health and wellness, everyone is concerned about it.
Yeah.
And it frustrates the rank and file, the officers, the superior officers, everybody that's under the chiefs, when their opinions are not asked. And when you're talking 18 to 20,000 police officers as opposed to maybe 380 chiefs, that's a big number.
Sure.
And so I want to make sure that I put that on the record, that I believe that this should also go to the heads of all the union institutions and let them weigh in as well. If we're going to send a survey, it should include everybody, not just the chiefs, because everybody's concerned about the same topic. So
Yeah,
if I
But
could-
this has been in our public materials since July.
I'm sorry.
This has been part of the public materials since July, this
An
proposal.
earlier
Yeah.
version
So
of
it's
the
not like
survey.
it's brand new today.
No, I'm not saying that.
Okay,
What
so-
I'm saying
yeah,
is
just wanna
that,
make sure.
unless I misunderstood, that conversations were had with Chief Baker and Eddie Crispin, who were part of our commission.
Right.
And then they were-
Survey.
And then they
Right.
were, and then it was also had with two other individuals, who one I know is a chief and one, like, I apologize, I missed. What I'm saying is I would like to suggest that it goes to all of the rank and file unions to also weigh in, because
That-
those organizations had a hand in passing legislation that enacted peer support units around the Commonwealth. So this is a big deal, and I wouldn't want to miss anybody and not say something at the table.
yeah.
Yeah.
So I think that's a great input, and we did talk about, possibly having a separate survey to send to, officers, because we know that officers have a different perspective of things than, chiefs. So if you think, that would be helpful, so we can kind of tailor the questions more towards, the rank and file, officers or to the, CBUs that, represent them, we'd be happy to do that and present that as well.
Yeah, we'll do that. We'll do that for the heads of unions and so on. I think when it comes to, going down to the officer level, we really need to be, methodical in the survey methodology. We want to have a target response, to kind of like have some validity, make sure we're not sampling from a particular group that's not representative, that sort of thing. The idea of deploying these two agencies was that we could get a quick scan simply by asking as many agencies as would like to see what kind of programs are out there. But when it comes to the officer level, I would be particularly interested in knowing what kind of awareness and what kind of usage is out there for officers. And it's one thing that an agency have, let's say, a program, free gym, workout time, whatever, and it's another to know whether the officer is A, aware, and B, using it. So that might be going into the officer level is in my opinion, a different effort. But we will certainly, just to formulate the survey, as you can, comment, Commissioner, we'll forward it to unions and organizations to see what kind of feedback we get.
Well, now that you explained that better, I can go first if you don't. Now that you explained it better, I fully understand the intent there. Maybe the request being the same, could we send this to the heads of the CBUs? Maybe not ask them, tell them that their reply is not necessary, that this is geared towards the chief and departments, and that a secondary survey will be following more geared towards the rank and file, but I would still like them to get this document, so they know what's going on as well, if we could do that. I'm in full support of what we're doing. The only thing I didn't hear, which would have been my next piece, is certain pieces where they're voluntary or mandatory, but I think we can have that conversation at a later date anyway.
Sounds good.
Masha?
No, that makes sense.
Could I jump in?
Oh, Tanya's back. Yep, go ahead, Tanya.
Yeah, I find it amusing that I was sort of kicked off just as this discussion started, because this is probably one of the things I care most about. I think I heard some of the points, but forgive me if I'm reiterating some of the statements. I missed a portion of the discussion. I just would like to make a couple points again. One is that as was discussed, I think that there is a significant difference in the priorities among the chiefs and the administration and the rank and file officers. And so it's good to hear that we're aware of that and recognizing that getting input from both groups is important. The second thing I want to say is that I understand the rationale for doing the survey, combining the psychological and physical fitness components for the sake of efficiency. But I really do want to make it clear that in my view, there is quite a difference between those two categories of fitness. And I'm concerned that by combining them, that we may lose some information about what's going on with wellness and psychological fitness. And also I sort of hear the beginnings of a suggestion that we may head towards having these fitness standards fall under training. And so I'd also like to make the point that there's a very big difference between having a physical fitness requirement fall under training and a psychological fitness fall under training. And I'm very much against having psychological fitness or wellness fall under training because of the issues of trust and confidentiality and vulnerability and the sensitivity of information. I just don't feel that those concerns will be best addressed by having that standard fall under an authoritative agency. And that we need to think of another way of addressing that aspect of wellness. And then the last concern, which I think Enrique, you were just discussing, is just the issues of the integrity of the data, and if we don't have a way of ensuring that all or most of the agencies respond, then what will the bias be that we'll get back when we receive that information? So just to be aware of those kinds of issues.
Thanks, Tanya.
Thank you.
You still good, Masha?
I'm good.
Anya, the one thing that you did miss is, Marshall and I didn't want to move this forward with a motion that was already passed, without your okay, but are you okay if we move this forward to the full commission as well and send a survey out?
Just to send out the survey, what are you saying that we would be moving forward exactly?
So we're gonna send this survey out, but also let the commission see this document when we partake in the recertification discussion. Is that okay?
Yes, thank you.
Director, that will.
Yep, that's fine.
All right.
But we're sending it, just to clarify, we're sending it to the heads of unions to get feedback.
Send it to the heads of unit for notification, and then if I understood correctly, we're gonna develop something more geared towards the rank and file. Is
Yeah.
that correct? I'm
That's an
completely
option.
fine
Yeah.
with that, sure.
Yeah.
Masha?
I am, yeah.
Yeah, Heiner, you're good with that?
Yes, I am.
Okay, all right. The only thing I didn't ask you, Heiner, is anything that we didn't anticipate? I always forget to ask that at the end.
I didn't anticipate it if it's not here.
Excellent. All right then. With that, I thank everybody for coming and taking the time to be here, and obviously my two commissioners, thank you very much. Smooth sailing today, so a motion to adjourn.
So move.
Thank you, Heiner.
Yes,
Excellent. All right. Have a good
Thank
day,
you.
everybody. Thank you. Yeah,
Bye, Anya.
I.
thank you.